This is Chris. I'm stuck in the elevator. There's been a crime afoot.
Você es la raza.
Ma'am, what's your job duty? Man, this lady just locked us inside of a vault.
Welcome back to the channel, everybody. It's Frauditor Roundup with Sheriff White, a moron. Help my channel continue to shrink by watching my videos, sharing my videos, commenting on my videos. I'm now offering memberships. Turn on that notification bell. Turn on all the notifications. Instead of messing with the like button today, in honor of today's subject, I'm going to offer a lawyer joke. What's the difference between a dead snake in the road and a dead lawyer in the road? There's skid marks in front of the snake. So today I'm doing something different. Normally, if you watch my videos, you see me making fun of insufferable idiots. Well, today is going to be the opposite. I'm going to highlight one of the best parts of YouTube. It's a channel for an attorney in California that goes by the name Patrick J. D'Arcy. Channel name is Hoya Lawyer. I love saying that name. And he's also a friend of the channel. I love watching his videos. He's one of those channels that you turn on, you know you're going to learn a thing or two. Now, lately, he's been chiming in on the Chille DeCastro situation in Nevada. And what's really dumbfounding me is he's getting a lot of hate for being a quote-unquote Chille hater. If you watch his videos, you know that's not the case. He's been watching this case like a student of law. He's curious about the legal ramifications on both sides. In fact, he's offered information that would help Chille. So I don't know where all the hate's coming from, but I, for one, I'm tired of it. So I want to do what I can to kind of help right the ship here. If you watch him for any amount of time, you know that this is a decent human being, not what you'd expect out of an attorney. But he's smart, he's loyal, and I think he's honest. And I think we'd all be a little bit better, a little bit smarter, if we listened to him a little bit more often. So what I'm going to do is I'm going to open by playing some parts where he was on a live stream with Digback Patrol, along with Frauditor Ram, watching the appeal where Chille won. It was kind of a Hail Mary, but of course, Counselor D'Arcy was a gentleman about it and congratulated Chille, but of course, people on the other side, they don't listen to that. They just think he's the enemy. So, gonna put this out there, showing him time after time, congratulating Chille, addressing a comment by a troll, and then I'm going to put out a follow-up video he did showing the mistakes the prosecution made in that appeal. So I hope you watch this one. I hope you learned something. And let's round us up some trolls. That's it. Some trolls.
I am absolutely shocked. You know me, I didn't think he would win this appeal. And Orm did a great job. First of all, he got the reversal, so he did a great job. But I got to give Chille the credit. He got the win. He gets the win. I have to tip my hat and give it to him.
You know, this guy keeps saying this over and over again. So there you go, buddy. You got your attention. You can stop saying it now. But, I mean, I don't hate Chille. I just find all this really fascinating.
Yeah, can I respond to that?
Absolutely.
I don't know. You know, first of all, I don't hate Chille. I don't know him. Okay? I'm just here to look at the constitutional questions. And if you were paying any attention, you would have noticed that I put up videos that I spent a lot of time on, which gave him information that would help him. So no, we're not haters. We're just trying to analyze the stuff as it hits us. And I'm going to tell you right now, did you just hear me say that I tip my hat and congratulate him? So would you knock it off and open up your ears and think for once?
I think I speak for us all when I say, I wish this is what he said instead.
You know, first of all, I don't hate Chille. I don't know him. Okay? I'm just here to look at the constitutional questions. And if you were paying any attention, you would have noticed that I put up videos that I spent a lot of time on, which gave him information that would help him. So no, we're not haters. We're just trying to analyze the stuff as it hits us. And I'm going to tell you right now, did you just hear me say that I tip my hat and congratulate him? So would you knock it off and open up your for once?
There you go.
You know, I think that is a good look for Counselor D'Arcy.
You know, Chille's got his haters, but we're not those haters.
I will happily go on the record as being a Chille hater.
Okay,
Yeah.
we were not his adversary, never have been.
Yeah.
So the fact that we're commenting on it doesn't make us a hater. It doesn't make us pro Chille. We're actually pretty neutral here. We're just trying to figure it out and look at it. And like I said, you know, lightning struck today. That doesn't make us haters. It doesn't make us trolls.
Yeah.
Sounds like that's what you are.
Patrick was laying out arguments that Chille could have used. I mean, not that it ultimately mattered, but he was not taking any sides in any of this.
Yeah,
So,
Chille supporters have actually notified me many times that they thought I was actually helping him. And I had other people saying to me, "Why are you helping this guy?" And I said, "Well, I'm really looking at it on both sides. What would help the prosecution? What would help the defense? Because arguments are going to be made on both sides, and I wanted to look at those arguments."
Let's fast forward to a video he put out here recently where he showed what the prosecution did and, more importantly, didn't do.
So I thought for posterity, I would show Judge Levitt's signed order and then point out the errors in the signed order. So hopefully the people will look at this, the DA, and realize that they need to appeal a completely wrong decision. So let's first take a look at the order. All right, so we know who wrote it because we always have this thing which is very irregular. And then, of course, you get the word in the parentheses. Remember, that is a rule of construction followed by very few practitioners. He asserts 4 claims on appeal. Actually, he asserted, it was past tense. Anyway, the 4 claims, he lost on 3 of them. The ones he lost on were ineffective assistance of counsel. Of course, had the DA actually spoken up at the oral argument, he would have mentioned that Michael Mee is listed on March 20th on the notice of appeal. I was the only one that brought that up. And that Michael Mee is lead counsel on the 1983 civil rights case brought in federal court, which is hanging by a thread subject to dismissal.
Look, I've said it over and over and over. I know fancy big city lawyer. And that's one of the details that might have escaped me. But when you think about it, it makes a lot of sense. So Chille is here on the one hand arguing he had ineffective counsel, while on the other hand, using that same attorney on your federal lawsuit. That don't make no sense.
The other one was that Judge Zimmerman was biased. I said that would lose. And then finally, the unconstitutionality of the statutes was a laughable argument. First of all, Wilson, in February 2024, declared the statutes constitutional. In November, I criticized the statutes as overly broad and subject to attack because of how badly written they were. Wilson proved I was right about that when that decision came down 3 months later. So here's the order. First Amendment claim survives. Okay. Bork testified he instructed DeCastro to back up. Yes, he did. And he did back up. And that's true. And it did not vocalize that he should back up 21 feet away from the officer. That is a red herring because the officer safety issue really wasn't the issue. It was privacy. And true, he never said how far, but this is a sideshow. Then they mentioned Wilson because Wilson is important. Law enforcement has no discretion or person to protect his speech or physical conduct merely knowing or offensive. That's right, because it's all First Amendment protected activity. And then they said where non-aggressive behavior may cause obstruction. They do now kind of get into what I've been calling the Wilson exception, but they cleverly stay out of it and makes this order wrong. This is untrue. That glick, which Orem called click, was relied on by both sides. No. Actually, in the prosecutor's brief, they distinguished the case and only responded to it, but they did not rely on it. False statement. Now, this is another false statement in this order. The Wilson decision established finding obstructing the pathway and leaves out the other grounds for obstruction, which includes under Wilson's exception, disobeying a lawful order or command. They said that would count as physical conduct or fighting words. Notice that it's missing from this order. He didn't actually go through what happened at the traffic stop. He glossed over things that would count as obstruction. And remember, I'm going to show you the federal court that looked at Chille's own complaint and deemed obstruction on the first refusal to comply with a command. Under the statute, you just have to disobey one time, and that's good enough. Then he wrote, this court found that none of the criteria for obstruction as defined in Wilson were met in the present case. That's untrue. That is flat out wrong.
So a couple things. One, I think the prosecution came into this appeal thinking they just had it in the bag. Or two, they were just not fully prepared. Although I guess two things can be true at once, right?
And then we get to the numbers and the parentheses. Okay, so that's where we are with that one. Now, let's take a look at what the federal court said. It says, DeCastro had been recording the incident from 10 feet away and asked her if she was okay. Bork left his patrol, told her to back up, which he did. Bork told DeCastro to back up further, but DeCastro stated he had a right to be there and was a member of the press. Bork threatened to obtain DeCastro for obstructing, stating that Jane deserved privacy. DeCastro repeated that he was a member of the press, at which point Bork indicated he was detaining DeCastro. This is the 1983 claim. The judge is looking at it. Even taking the amended complaints allegations is true. In other words, what Chille is saying, the officers had probable cause to arrest DeCastro for obstruction. Then he cites the statute. By the amended complaints allegations, in other words, by what Chille judicially admitted, Bork was in a police interaction with a member of the public. DeCastro started recording, moved within 10 feet, and spoke to her. Those are all true. DeCastro obeyed Bork's first command to back up. That's true. Bork told to back up further and threatened to detain DeCastro for obstruction, but DeCastro refused to do so. So in the federal court pleading, DeCastro, Chille is talking about how there was a second command to back up. At the trial or during oral argument, they only focused on the first one and then left all that out, plus the other obstructions that are clearly obstruction. Orem never brought it up, and the prosecutor never said, hey, roll the tape. And so the judge dismissed some of these 1983 claims with prejudice and allowed Chille a chance to replead them again. I don't remember if he actually did. The responding brief by the people said it exactly right about Wilson. Notice that it says blocking the path of an officer, which is all that's listed in the order, would be grounds for obstruction, or refusing to obey a lawful order. Nowhere did Orem talk about any of the lawful orders that Chille disobeyed, all of which would be grounds for conviction. All of that was kept from Judge Levitt.
I think this just goes to show again what a poor job the prosecution did. The judge can only hear what's brought in front of her. And all these great points that the prosecution had, well, they just left them in their pocket.
And the prosecutor had it right there in their brief, the correct citation to the law, right here on page 12. Here's where Glick was not relied upon, out-of-circuit authority. Glick is distinguishable from this case because the individual film was no way interfering with the officers. Here is the actual decision by Wilson that has the Wilson exception that's not listed in the order, so it incorrectly describes the Wilson case, and it was not mentioned at appeal, the exceptions that would apply to Chille, and the DA never brought it up. It says, we interpret obstruction as applying only to physical conduct and fighting words. We note that the statute does not require the use of force or violence, and that a person's action, e.g. Now, e.g. does not mean only. E.g. means, here's an explanation of it. Blocking the path of an officer or inaction, refusing to obey a lawful order may, which means doesn't necessarily, it's a question of fact, constitute physical conduct that hinders, delays, or obstructs an officer. Notice that it says the Wilson decision establishes fighting words, physical conduct, obstructing the pathway, or fleeing an officer as standards that apply to obstruction. These are not the only standards. This is an incorrect statement. Now says that these are the only categories that the court had to look at, was whether or not he fled, which he didn't, or if he obstructed a pathway, which he didn't. So, you know, there it is. This is a false representation of what actually the case says, and the order is false. The order is wrong. Watch Orem get caught. He says the 21-foot rule doesn't exist, but he does see it used in his defense cases.
21-foot rule because it didn't, it's not applicable. They sure did at trial, didn't they? That's what they argued. Even the prosecutor argued it. So Mr. Chen is only retreating from it because it's not a rule, and it makes no sense. It's something used, as we talked about, in self-defense type issues.
It's not a rule, but it's something to use in self-defense cases. So it is a rule. Okay, let's just call it for what it is. Is it irrelevant? Yes.
Citation started, and Mr. DeCastro got, well, you're not going to do that. It's obstruction. This is an obstruction. And the 10 feet, I agree. Is it 10 if you're only 9.5 feet? Is it correct? No, I don't think that's the point. The point they're trying to make is that our statute tells us we can film police officers. It doesn't say 10 feet, 21 feet, just says filming them. When he was told to back up, he did. And the state is now saying, yes, we all agree with that. We're quibbling over words. I'm only quibbling over words because they kept saying at trial he wouldn't back up, which is not quibbling with words, it's inaccurate.
Actually, it's very accurate. This is a spin, completely in reverse. And we'll see that.
That's true. I mean, the officer did testify on direct examination repeatedly that he didn't back up.
Yes.
But on cross indicated, well, he did back up, he just didn't back up.
Substantial.
Yeah, he may have backed up inches. He didn't substantially back up.
Okay, so here's where the oral argument's about to get lost. We all knew right away that the judge was coming in for Chille's win. I mean, we all could see that. And here is the prosecutor, but he doesn't have a response. This was the time to say, roll the tape, Judge.
And this is what's so upsetting about this case. All the prosecution had to do was roll some video. Attorney Orem was just saying that Chille was compliant almost and was backing down, when we all know that was not the case at all.
Because now the judge is thinking, yeah, what are we here for? And again, it's all based on what Orem is saying, because you're getting nothing from the DA here, nothing at all.
We didn't catch them. So is that the standard? Can we film police officers, but if they're not doing anything wrong and I'm using obnoxious language, then I can be arrested?
Obnoxious language and I can be arrested. What about the non-compliant language that you keep omitting?
Is that what the standard? It isn't, Judge. The applicant.
Judge just agreed. She shook her head.
It have to be annoying.
Now here's where Orem selectively interprets the Wilson case. And again, the people have no response to the Wilson exception, which includes refusal to obey a lawful order. So all the DA had to do at this point was show that Chille disobeyed a lawful order during the videotape, which is in evidence. And this case is over. And Chille loses.
Really struggling. They almost sound like me in a bad murder case where they're saying, well, what is physical conduct or contact? Because that's what Wilson said. And they're struggling with it because they don't even, because there's no physical contact.
Now, this is a big gaffe. You never allow the other attorney to speak for you as to what you say you're saying. I made a judge laugh when I had someone try to do that to me long ago in court. I said, Your Honor, I'm really tired of him trying to put words in my mouth. I'm perfectly capable of spewing my own gibberish. And the judge laughed out loud because there's times where you just have to put yourself down in a way to get, approachable. And the judge says, yeah, counsel, stop telling us what he's saying. Tell us your point of view. And when it came back to me, so here's where the prosecutor would say, Your Honor, he's misstating my position. And now the judge is going to want to listen to you again because she may get a little confused. I don't think the state was struggling at all with the fact that he refused to comply. That was in their brief, but he wasn't arguing it.
Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control. And he was irritated. Maybe we understand. It's not.
Yeah, you can understand.
And that was the main point of the obstruction charge. And ask yourself, is that an accurate portrayal of what actually happened? Let's look at it one more time. And you will see that it is not. But the prosecutor said nothing. Is this all Chille did? Did only Chille do is back up and pull out a phone?
Conduct or contact, because that's what Wilson said. And they're struggling with it because they don't even, because there is no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control.
So he did nothing physical. The officer just lost control. The Wilson exception deems physical conduct to include the disobedience of a lawful order. So Orem is totally wrong here. The DA is not saying anything, and the judge is relying heavily on these two attorneys to sort it out in her mind. So you've seen this. It's all narrated. And ask yourself if any of these statements by Chille would violate a lawful order to comply. If so, under Nevada law, he's guilty of obstruction.
Pulled over. Oh, I see.
Back up.
What a terrible.
Back up. Got involved.
Oh, I see. Oh, gotcha.
You can film, you need to stay away from my driver. Back up.
Okay, so we have back up. Oh, I see. You know, I give Chille the benefit of the doubt there. But stay away from my driver, back up. So now there's a second command to back up.
Back up or I'm going to detain you.
Third request to back up. So Chille has backed up.
You're going to detain me how? In which way?
Away from my car.
Actually, I'm standing right here.
I'm standing right here. He's not backing up any further, guys. That's obstruction. I'm standing right here. Standing right here sounds like he's not going to move. I didn't hear any of that being brought up by Orem.
I'm at least 10 feet away, officer. I got to tell you, I'm a constitutional law scholar. You can do whatever you want, but just understand something. Your name will go on the law, sir. Mind your own fucking business.
Not your business.
Mind your own effing business. Did you hear that discussed at oral argument? This isn't offensive language. This is open defiance. And Orem never brought it up, and the DA never brought it up. It was never mentioned in the appellate briefs.
Not your business.
Mind your own business.
Mind your own business? That's Chille. That's obstruction.
I don't know which is more offensive. Having to hear this garbage one more time, or the fact that the prosecution just left that on the table. Didn't think it was worth pursuing.
I'm a member of the press. Go get in your car and do your job, little doggy.
Now, notice how this statement was brought up as deemed cooperation by Orem, which it wasn't. But Orem skipped over the mind your own effing business, mind your own business, on top of I'm standing right here. Go get in your car and do your job. Orem took this statement out of context.
Okay, go feed her.
You're being detained right now.
Okay, then detain me.
You're being detained right now. Okay, detain me. So there is no unlawful detention. Chille's just consented to it.
That's right, he did consent. Woo-wee! I could never be a tenth as good as Counselor D'Arcy. He catches little things like that.
You're not.
Was any of that brought up at oral argument?
15, Rodriguez.
Over my car.
Don't put your hands on me. Don't touch me. Don't put your fucking hands on me.
I am going to put my hands
No,
on
you're not.
Was any of that brought up at oral argument?
Well, there you go. I thought this was just a good opportunity to show what type of person Patrick J. D'Arcy is. Not only is he a damn good lawyer, but he's a good person too. In fact, if you live in the California area and you're considering a crime spree, I would suggest hiring Patrick J. D'Arcy myself. But of course, I'm kidding. I just want to highlight one of the good people out there and stick up for those who stick it up for me. Well, I can tell by that sundial it's time to say goodnight. Put a little beans on the fire. Little Brandy Alexander on ice. And as always, cuddle up with a clean shirt and a dirty woman. Anyway, good night. I bid you adieu.